Welcome, everyone. Now that we're started, we're very glad to have everyone. My name is David Fortney, and joining me is Elizabeth Bradley.
Hello.
Liz, I'm really glad to have you. For those of you that are not familiar with us, we are partners at the firm FortneyScott. We do a lot of work in the federal contractor EEO space, as I think most of you know. Little description of our firm and the podcast, et cetera, are up there. And I would encourage you, if you're not familiar with that, please check it out. But we want to really kind of move into some of these key developments. I'm having a sleep deprived week. How about you?
What sleep?
Yeah, what sleep? What, 8 days into the Trump administration at this point, and it's been robust. The president promised it would be an active first 100 hours, and it certainly has been.
Yep. Look at the executive orders.
Yeah, look at those executive orders.
I don't know if this is up to date. It was as of, 10 minutes ago, but it could be out of date already. Right? The number of executive orders.
I checked 30 minutes ago, so I think we're still okay, but it could change.
Key to the workforce, there have been 2 that were issued with regard to the federal workforce. We're not going to spend time focusing on those today, but they are good to be aware of. Those are reforming the federal hiring process and restoring merit to government service, and ending radical and wasteful government DEI programs and preferencing. Always remember that what the government puts in place for the government workforce is always a roadmap, a little bit of where they want to go for private employers. So be looking at those, be mindful of those, but they're not your action items today for private employers. Correct.
And also the president effectively as the CEO of the government workforce has much more autonomy. And I do think it reflects exactly what you're saying. I think it reflects kind of the desired policy. So as much as possible, they want those same changes to occur in the private sector.
Exactly.
Yeah.
Exactly. Another executive order we're not going into detail today on, but be aware of: defending women from gender ideology, extremism, and restoring biological truth to federal government. I'm so glad these titles are nice and short and concise. Key point of that is this gets back to the gender assignment and bathrooms, walk rooms, etc. So employers that have LGBT friendly policies and practices with regard to bathrooms, locker rooms, etc., need to be aware of some of the provisions of this executive order, and we need to be watching how it's going to be enforced and how the impact on private employers with regard to this language in the executive order.
Right, and we'll be unpacking some of those in some subsequent webinars that we want to do with you. The other thing, just for reference, the reason we have to keep stumbling around with these titles is that the executive orders have not yet been assigned numbers. They eventually will be assigned numbers once they get uploaded in the Federal Register and so forth. So everyone's used to shorthand 11246, rolls off the tip of the tongue. But these orders don't yet. They will have numbers probably in the next couple of days. But as we sit here today, they don't. All right. So, shall we get into the agenda a little bit about what?
Well, I do want to highlight that today is the first of what is going to be a series of webinars. As we sort of teed up, there's a lot happening. So we anticipate these webinars are going to be on a weekly basis unless we need to be doing them more frequently than that. So look for alerts from us on additional webinars. And also we have a reference at the end of this PowerPoint for the FortneyScott reference resource page that's going to be launched. So just want to do a little bit of level setting to know that all of that we just talked about, we're going to get into more as we roll through.
Right. So basically we're targeting, and we're still kind of building the airplane while we fly it for obvious reasons. But Tuesdays, we'll probably try to run these weekly and catch up on key events. So the key event for this Tuesday, 8 days in, right? Ending illegal discrimination and restoring merit-based opportunities.
Yes. So today we're going to walk through each of the key sections of the executive order. We're going to discuss the immediate impact on employers with each of the provisions and explore the action items for long-term protections going forward.
Great. Okay. Well, let's jump right in. You want me to take this one?
Sure, go for it.
Okay, fine. So there are, for federal contractors, there are 2 key provisions. Section 3 of this new executive order, and we're assuming that most people have at least reviewed or had an overview of these executive orders, so we're not going to go line by line. But basically, section 3 deals with what happens largely to current contractual federal contracting obligations and future contracting obligations. Section 4 applies to all employers, not just federal contractors, but all employers, and includes some significant new potential compliance and enforcement obligations. So let's start with kind of the basic overview. Everyone knows 11246 is rolled back. It talks about may continue to comply with the regs until April 21. That's 90 days.
I think that's an important period because there's a lot that we're going to be talking about that you need to roll back. You can't just turn off components immediately, and you may not want to, right? So this gives you 90 days to make mindful assessments of what is still required and what you may want to choose to continue to move forward with.
Yeah, this is what I call kind of the concept of unwinding out of 11246. We'll unpack that a little bit. But OFC was also given a number of other specific instructions by the president, the Labor Department was, in this order.
So the executive order directly told OFCCP to stop promoting diversity, stop holding contractors responsible for affirmative action, and stop allowing or encouraging workforce balancing. The EO was essentially silent on 503 or VEVRA, but there were a lot of questions. So this executive order came out on January 21st, and it left a lot of questions about open audits. What was, if they were opened prior to this, are they moving forward? What was going to go with that? So David, let's take it to what was this? What did the acting secretary of Labor?
So Tuesday night, the 21st, this order drops. Everyone had sort of a sleepless night the next day doing that. Then, of course, we have clients with a number of open investigations, scheduled on-sites, submission of pay data, you name it, across the board. And OFCCP does not, at that time, did not have a director in place. Michelle Hodge had been downgraded to her deputy position, and it wasn't clear. So one of the things, we've been in pretty regular contact with the transition team and key representatives of the new administration. And we raised with him, we kind of ran that flag up the flagpole saying, can you please put something out? I mean, whether you agree or disagree, the president's executive order is out there. It would be extremely helpful if there could be some guidance on how people are to comply, particularly for OFCCP, because they were kind of all over the lot. It seemed to vary by compliance officer. So very helpfully, Friday night, everything comes at night, by the way, after 5 o'clock. That's the time you have to check the White House website for updates.
I'm done cooking dinner anymore. It's not happening.
It's overrated. It actually lose 12 pounds, so that's okay. But so this order comes down, and so there is no confirmed Secretary of Labor. There's the acting Secretary of Labor, Vincent McComb. The acting secretary issues an order, and that is the way agencies within the Labor Department are formally directed what they should do. And in this order, it's very specific to OFCCP, and you can read it for yourself. We won't go through word by word, but basically it is a complete stand down on 11246. There's to be no more audit activity, no more enforcement, nothing, because the underlying executive order 11246 has been rescinded. What about the remainder of this, though? There's 503 and VEVRA.
So that stays in place. So I think, the what now, agenda, I think we can move forward. The what now is, because I think prior to the cease and desist order coming out, contractors were still saying, well, I'm working on my desk audit submission. I think it's still due. I don't know. And you're not going to stand down because you want to be in compliance. You want to be prepared. So here's what's happening now. We've heard from some compliance officers who actually reached out to contractors and saying, hey, everything's on hold. Not all have. So there's a little bit of piecemeal still in the communications. I mean, I heard on the 21st, there's still scheduling letters going out by a couple of compliance officers.
Crazy.
That had to have been a mistake. But so 11246 enforcement is done. That includes obligations under conciliation agreements. So if you currently are under a conciliation agreement and you need to be preparing reports, that work is done. Those obligations are no longer active, no longer enforceable. We think closure letters, or at least closure communications. I don't know if we'll get the formal letter, but you will be notified that the 11246 sections of your audits are closed. You will not be required to submit any desk audit materials for the 11246. And the 503 are being held in abeyance. What exactly does that mean? We're not entirely sure yet. But we think that ultimately, you know, I think it's ultimately the elimination of OFCCP and the redelegation of the 503 and VEVRA enforcement to other entities within Department of Labor.
Right. So this is kind of a tricky part for the administration. They obviously want to wind down these obligations. The executive order, that's the power of the president, 11246 rescinded. And you can see that's effectively gone. So preparing AAPs, et cetera, on that's all gone. And I know some people are still running around, should we be preparing AAPs? There's certainly no legal requirement to do so. With respect to 503 and
Let me
VEVRA,
tag
well,
on
let's,
that.
let's, like I say, let's, yeah.
Hold that because there's a lot of additional legal considerations before you decide there might be good reasons in that little
Right.
bit of an employment space to be doing that. So
But this 503 and VEVRA, because a lot of people, of course, they historically have prepared all three AAPs
right.
simultaneously. 11246 is gone. What about the remaining AAPs? I think many clients are continuing to, even though OFC has held their enforcement in abeyance, not clear whether the obligations, the statutory obligations, are in abeyance.
So I think they are not. So this is where,
I don't know.
Right.
Yeah.
I think it right now, because it's unclear, and many of you probably have calendar year plans out there. You're probably in the process of preparing them. Going forward and completing your 1124 or your 503 and VEVRA AAPs, you're in the 90-day period. The laws are still on the books. I don't think there's a risk in doing those.
Correct. I don't disagree with that.
Right. Okay.
So let me pick up on one crystal ball point, because we sort of threw it out there and people may have been gasping or clutching their pearls. What do you mean eliminate OFCCP? How could that be? I think the following scenario occurs. I think that the Secretary of Labor nominee is confirmed. I think the Deputy Secretary is confirmed. Once those two positions are confirmed, then they take the statutory programs, 503 and VEVRA, that are given to this Department of Labor. The Secretary will redelegate.
Yep.
503 goes to ODEP and VEVRA goes to DOL vets. And then OFC becomes unnecessary and is necessarily abolished. From their standpoint, the administration, that's a savings of about 500 FTE, $100 million budget. It also would have residual effect savings with respect to solicitor's office and other support functions. So, when does that occur? Possibly by Memorial Day.
Yeah. And I think some of this is, if you recall, in the prior Trump administration, there was a lot of talk about combining OFCCP with EEOC. So the concept of OFCCP going away is not new.
Correct.
So this is not a unique concept here.
All right.
So what remains? So what's moving forward?
Yeah. So let's talk about this 90-day wind down. I'll just what remains. We have this compliance grace period.
Yep.
And that's what we think of as a wind down. There are a variety of things that you well-counseled contractors, and I expect everyone joining this webinar today, their organizations had in place to comply with the 11246 regulations.
Mm-hmm.
Those regulations now are gone. That's the point that I want to really make. So there's no justification, which is, to your earlier point, Liz, why this period of time to get your house in order,
right,
to get those cleaned up.
But there's something to be thinking about, is you need to go through mindfully and
Yes.
look at all of your legal requirements and not just say 11246 required this, so it's gone. Sometimes 503 and VEVRA also require, for example, the EEO tagline. So that's going to need to be modified because it was required under 503 and VEVRA and a portion over 11246. So each one of the components of your compliance, you need to be looked closely at what is still required under federal law. And don't forget your state and local laws. They also have affirmative action and non-discrimination and other provisions that some of your 11246 actions are also in furtherance of those laws. So that's why I don't think anybody should be making any rash decisions. I think you need to catalog your various state and local and the federal obligations and figure out what you're doing to comply with which.
I agree, and a couple of other points I'd like to make on this. Number one, it's noted on there about an attorney privilege basis. This is not a regulatory compliance task. This is really sorting through what is legally required, what's legally justified or not. And I would strongly encourage the companies should, in coordination with their in-house counsel, get this organized such so that it is done on a privilege basis. That's point number one. Point number two, a number of contractors are very concerned that their current contract instruments contain terms that effectively allow the federal government to enforce Executive Order 11246 and the related obligations. That has also been addressed. The GSA, General Services Administration, has issued an instruction to all agencies to forbear from enforcing those contract terms. Again, in the resource page at the end of our materials here, we've given you a link to that. So essentially, not only are the regulations gone by operation of law, not only is the executive order gone, but effectively your federal contract terms are not going to be enforced. They are moved at this point.
Correct.
Yeah, they're just legally, because the other party to your contract, your federal customer, isn't going to enforce them, not surprisingly. So I think that those points are very important, and this is not just a mechanical compliance point. I think there's a number of pretty dense legal points that need to be thought through carefully.
You also need to be looking at beyond the legal requirements. So what we're thinking about here is you are no longer required to collect, for example, race and sex data of your applicants.
Mhm.
Do you want to? Is there a legally defendable basis for asking for that data? What are you going to do with that data? And you need to be carefully considering the legal benefit versus the risks of what those actions are going to be. You can still do voluntary plans, but you need to be thinking about it holistically. And we're going to be talking about some of those additional legal risks as we move forward today. But I think that needs to be a holistic discussion within your organization about what the legal basis for continuing to do that, knowing that there are potential risks.
Agreed.
All right.
All right. So what's left? This is what many contractors are sort of looking around like, so what's there? Well, we have mentioned the 503 in VEVRA. And it's interesting, the executive order itself also makes reference to a specific statute dealing with accommodations for the blind, which is sort of strange. I mean, it's not strange that we have that statute, but
why that one?
Why that, and why wasn't 503 called out?
Or VEVRA even.
Yeah, so anyhow, all of those requirements, they're statutory, and the statutory regulations that the Labor Department has promulgated, initially OFCCP, remain in effect. And if that transition to different agencies occur, that won't change the regulations. They'll just do a very, search and replace, put the name of the agency in, but the regulations will be the same. There could be regulatory changes going forward. We don't have any information on that. And I just would put out there, because we're going to pick up on this for a different point. In the current administration that is expressed a very strong deregulatory preference. Indeed, for every new regulation issued, you have to point to 10 regulations, 10 former regulations that have been removed. The former standard used to be a 2-to-1 ratio. Now we're up to a 10-to-1 ratio.
Buckle up.
Yeah, buckle up. What that means is not many new regulations will be forthcoming, because not many will clear that bar.
Threshold.
Yeah.
Right. It's another important, Title VII and all federal anti-discrimination laws, they're still there. They are not gone. It remains unlawful, and it has always been unlawful to make any employment decision based on any protected category. That actually has been our foundation and a baseline. And 11246 was just to provide additional affirmative action and on top of those protections of discrimination against anybody. It has always been, and it remains unlawful to do preferential treatment, set-asides, quotas based on protected activity. Always been a problem. You're doing your proactive pay equity, only adjusting the minorities and the women. Those kinds of actions were never appropriate under Title VII, and they remained inappropriate under Title VII. So I do think one of the things is we're brought back to the foundation and the guardrails that were developed and put in place by Title VII.
I'd say one other thing that remains, and it's, I think, implicit in all this, we're not going to unpack the state laws, but of course, there are a lot of state
Yes.
laws, many of which are more, I'll say, robust than at least the federal law as it's being currently interpreted by the current administration. And I predict that there are potential for some differences in
Yes.
state law requirements and federal law requirements. I hesitate to say whether they're actually conflicts or not.
That's where the rub's gonna be.
Yeah, and that's where the rub's gonna be. So we're, as they say, we're gonna put a pin in that, and that's something that we are mindful of because we're beginning to see, again, this is what, 7, 8 days old. Some states are also beginning to wake up and say, well, wait a minute, if we don't have this robust federal program in place, maybe we as a state should be standing up more protective statutes, more comprehensive regulatory requirements,
There's
whether you're.
states that let you submit your federal AAP to comply with their
Right.
state obligations. What's gonna happen there? So stay tuned.
Yeah, stay tuned. We can't answer that today, but we recognize that is part of the, what remains landscape and
Yeah.
part of what's gonna be coming. All right.
So let's talk about one of the big deal portions. So I think what we just got through was 11246 is gone. That's the old guard is gone, and with the impact. We're now gonna pivot into the sections of the executive order that is putting new obligations.
Federal
in place.
contractors, we're not done with you.
We're not-
It isn't just that you lost obligations.
Correct. So so what are the new components, David?
So this is a provision, and again, other than the executive order, we don't yet have language in the procurement regulations or any other regulations or information. So we're within the four corners of an executive order, which is very 50,000, 100,000 foot level. But the executive order prescribes that in all federal contracts going forward, there will be a provision in addressing compliance with all applicable federal anti-discrimination laws, and that these will become material to the government's pay decisions under the False Claims Act. We're going to separately unpack that FCA, that False
Yes.
Claims Act point in a moment. The materiality point, in plain speak, what that means is, if a term's material and you don't comply with it, it provides a basis for non-payment. So it to some degree, I think this actually.
And liability under the FCA.
And liability, it amps up in terms of contractor corporate exposure and necessity of compliance. It's no longer just an OFCCP slap on the wrist. It's no longer, I mean, very few people got debarred.
Yep.
That was a remedy that wasn't used much. But this is a broader remedy that could be used certainly much more. Additionally, there's going to be a new certification. We're used to an existing certification introduced a couple of years ago in which you simply certified effectively, we comply with a federal contractor regulatory scheme.
Mhm.
Now, the certification would be that the employer does not operate any programs promoting DEI that violates any federal anti-discrimination laws. And interestingly, although the executive order is honed in on these DEI programs, that's clearly the focus, the White House issues a fact sheet, again, we've got that linked up for you in the end here, that says, well, we said DEI, we really mean all discrimination.
Well, and it says, regardless of what it's referred to or how it's.
Yeah, this is what we meant. So this, I'm reading, I mean, the clear body language and express language coming out of the administration is they want full attention paid, in contrary to some of the popular criticism, they're not backing away from anti-discrimination. In fact, I would say they're doubling down on anti-discrimination, but it's the honing in on the DEI.
Yep, and another piece, flowing from the provision before, we talked about existing DE&I and other contract provisions that allow you to have compliance with those programs not being enforced. DE&I and DE&IA provisions are going to be removed from the FAR acquisition. So we expect the FAR to be modified to remove some of those provisions. That's a little bit of a housekeeping provision, but it's worth
Right.
noting.
And this point on grants, anyone on the call whose organization is involved in grants, grants were suspended. That did occur last night. The OMB has issued an order suspending grants. So stay tuned on that. But if you're involved in the grant activity, you should look at that OMB memo, or we can provide it to you. We didn't link that in the resource page, but if you need that, follow up with us, please. We'll get that to you. All right.
So we want to take a minute to talk about the False Claims Act.
Yeah.
This is a
Kind of new ball game.
new ball game, and it's a big deal, and it's where all of these various components need to come together. So under the False Claim Act, a knowingly false claim includes, obviously knowingly false, but also reckless disregard for the truth and a deliberate disregard. So this, I'm clicking back to what we were talking about before. So you have to certify, or your contract requires that you are in compliance with all anti-discrimination laws and that you are not engaging in an illegal DE&I. And you have to certify that knowingly, without doing a knowingly false certification with every invoice you submit. How are you going to be comfortable doing those? And that goes to the, I understand that there are some reasons why in employment practices you may want to be gathering applicant data and running those analyses. But what if those analyses show a disparity, David? What if you end up getting data analytics that show you have a significant disparity, any race or gender, and then now you have to go forward and do a certification, or you have these contract provisions. Where's that?
With real teeth in them.
With real teeth in them. So
well,
these are all, go ahead.
Yeah, no, I was gonna say, I think this is a point that you've made to me, and I think it's helpful for everyone to think about. We have had most organizations longstanding practices to pretty regularly assess our compensation system.
Right.
Sometimes annually, sometimes every other year, what have you. And I think the sort of the standard ground rules that everyone understands is, A, we may not be required to do this. Question whether you were or not as a federal contractor. You know, that helped in terms of providing a legal justification. But now there is no specific requirement to assess pay or these other practices. If you go forward and do it, you need to be prepared to act on the results. Yeah. And so if you come up with, these are often, statistical assessments of your practices. If you have disparities, running those to ground. And again, this pretty sophisticated audience, we know what all that entails. That's a lot of legwork and resources involved. But I think you need to get to the point that you are comfortable and then fashioning, if necessary and justified, appropriate remedial actions as may be required. Those could be pay adjustments. They could be potentially even retroactive. There could be a lot of things.
Or if you're looking at your hiring practices, modifications there. Because the other thing we need to be looking at is, where is the certification going to, and how is it going to be facilitated? Often, under other certifications under the FCA, you get to engage with your contracting officer and say, here's how we're certifying and here's why. Here's some explanatory evidence or materials to kind of put it into context. If this is anything like the current OFCCP certification, which I'm in compliance, yes, no, where's that explanatory material come in and how is that? So there's a lot we are still unpacking and learning about how this is going to roll out. There's going to be some more rulemaking. Right. This is not going to be done by an executive order. But I think the reason we're spending a minute here is all of this needs to be taken into consideration. We want to make sure your right hand isn't moving forward to what the left hand needs to know about, and putting into full context your considerations with regard to continuing to do data collection and what that data analytics is.
So unwinding 11246 doesn't mean no longer paying attention to anything that's going on, because I do think, I'll call it the ostrich approach. Right. Simply, I'm not going to look at anything in my
that's not the approach
workforce, right? Because in that way I can certify, because see no evil, speak no evil. I can report. I'm good.
Deliberate disregard.
Deliberate disregard, and that isn't good enough. So there is, what specifically is required. we're entering into a period whereas before we had OFCCP regulations that were highly prescriptive
Mhm.
and at least provided a jumping off point. We no longer have that. So something, not the ostrich approach, and probably something reasonably robust so that with confidence, because otherwise, most of you are large organizations. Think about it. You hopefully have no more than a handful, but you have various EEO charges pending.
Correct.
Knee-jerk reaction is, of course, that we shouldn't have a cause finding, and we're challenging that, disputing that. But sometimes you do get a cause finding. Does that mean that you're not in compliance? Most organizations say no.
What about you get that EEO charge and your in-house counsel and you look at it and you go, oof.
Yeah.
Can you do that certification?
Right.
There's a lot to unpack here. And
So the historically, in terms of general contracting, where these types of certifications occur, it does include the ability to say, we have a good faith, well-informed program. We've gone to
Correct.
council, we've stood it up, we follow all the guidance, we double check to make sure it's operating. Yes, we have a handful of charges. Here's the reasons why we don't think that that evidence is that we're not in compliance. You can appreciate kind of where that's going, and I think that's what will come out of this. But we don't know. That's a little bit of crystal balling, but I think it's helpful for people when we say wind down 11246. Don't lose that institutional capability. Maybe redeploy. All right.
one last
How about-
piece, one last
Okay.
piece on this, and then we'll move on, is again, the standard for False Claims Act is knowingly false. And you're gonna have to be certifying that you're not engaging in illegal DE&I. One of the components is you need to be thinking about is if you rely on a legal opinion that your DE&I provisions are not illegal, that is often a good faith defense to an allegation of knowingly false. So again, you need to be looking at these not just as an HR DE&I component. Your legal team needs to be involved and looking at these as well.
We mentioned these key TAM actions. That's typically how False Claims Act claims are asserted. Think it's a private attorney general concept. This is a statute that was enacted during the Civil War, where there was rampant fraud against the government in providing munitions and war material. But private citizens basically file claims on behalf of the government. The government sometimes joins, sometimes doesn't. They are incentivized because they receive a bounty. If there is a false claim that's reported, they are whistleblowers, and you can think about all of the protections that are typically attached to whistleblowers attach. So part of what is being conceived by the Trump administration is to leverage so that it isn't just the agency that has to do enforcement.
So the employee who feels that he was falsely made to sit through a workplace training that include unconscious bias now feels he is subjected to a hostile work environment in violation of Title VII. He can be a whistleblower.
The employee who wasn't hired, and she believes that it was because of some DEI initiative that caused him or her not to get hired.
Can be a whistleblower.
These are all folks, and I think that is candidly what the administration intends will occur. All right, that's part of the new landscape. Let's move on.
Section 4.
Section 4.
Okay, so this is actually also a very big deal, and this applies to all employers. So
I think this is almost a bigger deal than Section 3.
I mean, because
federal contractors have to do everything we just talked about, plus what you're about to unpack for us.
Correct.
Right? As do all other employers, non-contractors.
So this is developing a strategic enforcement plan against illegal DE&I applicable to all employers. Very, very broad. So first of all, this applies to all agencies. David, approximately how many agencies are there?
Well, I asked Google, and according to Google, and more importantly to the SAM.gov database, I believe the answer was 438.
Right.
Although, I don't know, I mean, the OFCCP, maybe it's 437 in a couple months, but anyhow. So there are literally hundreds, 400 plus.
So every agency has to provide a report that identifies by each of their sectors the most egregious and discriminatory DE&I practitioners. That's that list is, I know we hear a lot of talk about the 9. That list is more than just the 9. So there's that could be as broad as they
Right.
want to come forward with.
Unlimited.
Unlimited. Then within that report, there has to include specific steps or measures that each agency recommends that they take to deter illegal DE&I. And part of those steps is identifying 9 potential civil compliance investigations. So David, let's unpack a little bit what some of those compliance investigations are going to look like.
Yeah, so this is interesting because this reporting, I just find this a little peculiar, honestly. Each agency puts together its report and recommendations. That all gets funneled to the Justice Department,
Yep.
right? The Attorney General then packages that up, and normally things like that would be sorted out by the Justice Department. But the Justice Department now provides more recommendations, and they go to the White House. Not just any random person walking around at the White House, it goes to the Deputy Policy Administrator, that would be Mr. Stephen Miller, who currently holds that position. He's not in the executive order by name, but his position title is written into the executive order. From there, it states that this domestic policy advisor, Mr. Miller, is to make decisions on what comes next. And you think about it, you're sitting in the White House, you have all the tools of the federal government available. You have procurement agencies that could follow up, be directed to follow up. You have enforcement agencies, obviously, EEOC, that can be done. Don't get hung up, there's no charge. You can file, you can ask a commissioner to file a commissioner's complaint and go forward with that. The Labor Department does have various oversight. You can appreciate that potentially agencies involved in immigration issues could be involved. I mean, every agency, including those that may not be on the radar screen, the Bureau of Land Management, maybe they are on the radar screen, there's environmental. I mean, there's where this goes is very undefined, and there's a lot of questions. Is there Fourth Amendment protections or this? We don't know. I mean, the truth is, until this program gets shaped up a little bit, we don't know.
What we do know is between now and in the next 90 to 100 days, we have
120, yeah. Well, 120 from the get-go, so May 21, yeah.
But you don't want to be on this list. So, I think we're going to talk about that in the next couple slides of some things that we are recommending that you do in order to help ensure that you're not on either of those lists. That would not be a good place to be right now. Right. I think everybody's kind of working towards how not to be on this list.
I mean, this to some degree is, honestly, I mean, let's just sort of call it for what it is. This, at a minimum, has the potential to be a naming shaming. Complete naming shaming. This is kind of like Robbie Starbuck on steroids.
Yep.
Right? I mean, but now, driven out of the White House, the administration may be able to call out private employers that are engaging in questionable DEI practices of some, not adjudicated illegal, just questionable,
Correct.
People say this company's not doing a good job with this, etc. That can be tremendously damaging to companies in terms of reputation, workforce, etc. So this, I think, it's so vague that but it's very scary.
I think another component of this that we all should be looking for is it asks for recommendations on any regulatory action, sub-regulatory guidance. So everybody is asking, what is illegal DE&I? It hasn't been defined anywhere. Obviously, it's DE&I that violates federal anti-discrimination laws, but anything more concrete than that, we have not been provided. I'm anticipating that some of this regulatory action and sub-regulatory guidance is probably going to go into that, giving us more guidance.
I mean, there may just be some general statements.
My muddy crystal ball.
Although EEOC within the last 24 hours has pulled down some of its sub-regulatory guidance.
Correct.
So the agencies even, don't rely on the guidance that you've been existing under. I think this is part of it. We need to be mindful. There's likely to be either no guidance or new guidance.
Yep.
And old guidance is apparently going to be removed. All right. So where do you look? I mean, we're in this kind of funny period. It's like we're nervous. Many of these participants today I call them big fish. They're well-known household names.
How to stay off this list.
How do you stay off the list?
I
Yeah,
think you need to be looking at your public statements. What is out there where you have active statements about placement goals, your grand success in all of those successful goals and those diversity achievements? Look what you have touted and in your brag sheets that are out there and consider pulling some of that down.
well, many organizations are currently reporting on human capital management, HCM, data and information. You do have certain current regulatory requirements to issue those reports. You might want to think about and look carefully at those reports, make sure that obviously you are complying with what needs to be reported, but you may not have as many of the flourishes or build out that some of them have contained in the past. And I might add, looking at prior reports before this landscape change, those that were reported a year ago, we do know from experience that Mr. Starbuck, Mr. Miller have historically looked at those reports for purposes of targeting. Now we have people on a very different platform, but I think the same information, that's certainly one of our standard instructions to work with the client. We say, well, what have we said in the past? And do we need to modify it? Are we okay with that? Can we defend it, et cetera?
And I think that's another point where, my theme is here, making sure all the dots are connected. The audience here, you all may not be directly involved
Right.
in those human capital reports and where they are. They may be often in a different, and you're not fully aware of what's being said in those. So again, this is something where we need to make sure that everybody is aligned across your organization about what that language is and what you're touting and where.
Should we talk a little bit about some of the other, I call them common diversity related practices? And the first thing is simply doing a keyword search for the word diversity or DEI. That's not sufficient.
It's not.
No, and a lot of people say, well, I checked, and I, searched and replaced and I'm good. I never say diversity anymore. That's not what we're talking about. We're talking about in substance,
Right.
how programs operate. And so programs that have historically focused a lot on outreach and recruitment, that have said, gosh, we're underrepresented in women in STEM jobs. So what are we going to do? And a host of other examples.
Right.
Questions as to, are those personnel practices, should they be continued? Before we had justifications based on 11246 as contractors, the diverse slate programs, our slate, we're only going to interview 5 people. The slate isn't diverse enough. Do we remove people and put different people in based on protected characteristics?
So I think those are conceptually, you have to think of them a little bit differently. So doing a broad outreach and recruitment, absolutely, I think that's still fine. But if you're only doing outreach to a certain targeted demographic, that's probably not going to be fine. You're going to need to spread.
Yeah, I agree.
And I'm actually kind of thinking, we talk about outreach and recruitment as a one activity. I think they need to be thought about separately.
Right.
Outreach is your external, taking the net very broadly.
Right.
Okay. The recruitment is how are you pulling in on that net and making sure that you're doing that pull in, not just based on you've engaged with a vendor to help bring women applicants into your workforce, that type of stuff. I will say, and mine's differ on this a little bit, but the diverse slate programs, if done right, where you hire, if you want diversity in your slate, you don't lob people off or skip people, you just interview enough so that you interview a diverse slate, arguably is fine. In practice, I think we mostly know that that's not actually what happened because the hiring manager is not going to interview 10 people. Right. I think diverse slates were always on the line. I think diverse slates always were giving preference based on race or gender. And I think they always got a little bit close to the Title VII violation.
Well, if you removed persons on the slate and substituted based on protected characteristics.
So, depending on how you facilitate it.
So this is, the detail is important on this.
Absolutely.
So, but, and there are dozens of different, I'll call them typical DEI program components. And this little colloquy just illustrates the level of detail. And I think what this means is that you need to, in a very real way, and it's typically HR and legal working hand in glove, and ultimately with legal and corporate counsel or your outside counsel are going to need to take a look and say, thumbs up, thumbs down. We have a good faith basis to believe this is not illegal DEI. And that's the point you gotta get to. What about some of these resource groups? I mean, these are,
First of all, ensure that they're open to all.
yeah, I agree.
And ensure that you're not denying opening new ones depending on what the new ERG requirements are.
Can I still have a female leadership program?
I don't recommend it. Any of these programs, now, it's open to all, but are all, let's assume it's open to all, are all feeling welcome to join.
Right.
And I do think with some of those, any of those employee leadership and internal development programs, there's also minority in STEM programs, and
Right.
there's female leadership are sort of the traditional ones. I think those need to be reimagined. It shouldn't be, I mean, leadership programs are great, keep
Right.
those, but open them to all, rebrand them, and make sure everybody feels welcome and open
And
to
certainly at a
attending.
minimum, if you're having ones that are labeled female leadership programs, allow allies or others, everyone to participate.
Correct,
Okay,
correct.
all right. Let's just take a moment and talk about educational institutions. Liz, I'm gonna ask you to do that perhaps because the order, this is kind of a grab bag executive order, but anything involving DEI in the private sector, here we go. And there is section 5, which deals specifically with the higher ed educational institutions.
I think, please hold. This is the language in here is very brief with regard to higher ed. May 21, there is going to be some guidance coming out. I think we can anticipate it's essentially any consideration of race and gender in the admissions process, and probably, employment process as well, is going to be placed on hold, or deemed unlawful. So just higher ed, please hold. It seems like you're going to, because you are an employer, so all the other provisions, and you're also a federal contractor, so everything that we just talked about is applicable to these higher ed institutions. And now you're gonna get something else bolted on top of it,
And higher
so.
ed also typically has grants. And one thing I'd point out, since the education department has been identified as being on the chopping block, I guess they're not gonna be chopped till May 21st, because it appears that the Secretary of Education, it kind of
Right.
envisions there would be a Secretary of Education
Until at least May
till May
21st.
21st. So the Attorney General and Secretary of Education are to issue that type of guidance.
Right.
We'll see. All right, let's talk briefly then. So kind of putting all that together, we're not gonna go through each one of these item by item.
This is sort of our hit list.
But yeah, this is just kind of quick overview. I mean, recognizing you're unwinding 11246, you're also recognizing that you do continue to have 503 and VEVRA obligations. We've talked about, you can certainly close up any open OFC CP open matters. And if OC doesn't contact you, you strategically can think about when and how to contact them, or whether you do.
I do think that that's a fair,
Yeah.
any work on open audits, 503 or VEVRA included, ceases now. You are
Right.
just waiting for the formal notification, and asking clarity from the agency is perfectly acceptable at this point in
I
time.
think all of our clients that I'm aware of have put a stop work order on AAPs and for 11246.
Yeah.
And those efforts, we did talk about the new certification. We don't have all the detail coming, but the reason we emphasize that at this point is that as you're unwinding 11246, you wanna, I thought one client aptly described it as, maybe I mothball or preserve some of this muscle memory and institutional capability, and I think that's a fair way to think about it. There is this new contract clause coming. We will be obviously working with you all as that gets fleshed out, but it's one that will have real teeth. So if people are recalibrating, just a practice pointer, if you're thinking, oh, 11246 is gone, I can scrap my budget and turn it back in, I don't think so. As a practical point on that, what most of our clients are doing is thinking, okay, I don't need the 11246 AAPs and some of the other efforts or the audit, but I do have resources available. I'm going to repurpose those to start getting ready for this certification.
All right, and then this is the federal contractor list, and the next would kind of be a broader list for action items for all employers. Again, and this is the hit lists, what we've talked about previously today, but you need to assess, hopefully you're not going to be one of the most egregious discriminatory DE&I practitioners, but go through the topics that we talked about before. What do you have out there? What are your public facing is there any action you can take to ensure that you are not hitting that list? Similarly, looking at what are your risks about the civil compliance investigations? Have you had outreach from Stephen Miller? What are the communications you're getting? Do you have concerns that you may be a focus? And go ahead.
No, I was just gonna say the Stephen Miller point, I mean, his organization, AFL, I think it's worth, if you're not already familiar with the types of programs that AFL has lit up over the last 12, 18 months, you might want to take a look at those. If you have anything that looks like that is close to that, you should, in a meaningful way with council, take a hard look and say, are we okay?
Yep.
If the federal government raises a ruckus in every sense, formally or informally, naming and shaming or legal efforts, are we able to defend what we have here, or do we need to rethink it?
Yep.
If you need to rethink it, I would start that now. I would not wait to be lit up.
Correct. And that's like item 3 and 4 here. Get your arms around all of your, and we're saying DE&I here, but I again, to what David mentioned earlier, think broadly. I would catalog your programs, your assessments, everything from in the employee process, and develop a strategy to go review those. What are the components? Do you believe that they are any sort of illegal DE&I? And document your decisions there, because again, that goes to, do you have a legally sound basis for entering that certification that your DE&I programs are not illegal? So build the document and your assessment of those and your legal basis for determining that they are permissible.
A practice pointer on that, many organizations do use training services. They use a vendor or some combination of vendors that do have developed and present their training programs for them in various ways. It may be online, it may be in person, what have you. Do not assume that the vendor has done it in a way that will be compliant. So that, and again, it doesn't have to be DEI training. It can be, civility in the workplace. It can be, there's a whole host of things, harassment. I think that you very comprehensively need to look at what is going on in the workplace, policies, practices, training, outward facing statements, the whole schmear.
Well, and that goes to, and then you mentioned civility in the workplace training, and I recently reviewed one, which at the time I reviewed it, it was fine. This was what, 2 months ago now, but there's an entire section about civility in the workplace and striving to use employees' preferred gender pronouns. That is going to be, a bit of a touch base here with the carving back of the LGBTQ guidance from EEOC. So being mindful that even a civility training may have some components that are problematic under the Trump DE&I.
And some of this
measures.
also depends on your risk tolerance.
Correct.
I mean, there's some organizations out there, high profile,
Absolutely.
very public, Costco and JP Morgan come to mind, that have said, you know what, I'm not changing a comma. I've got these programs that are important, they're part of who we are, they're part of our value statement. I'm not changing anything.
Absolutely.
And we'll see. We're going to have some interesting case studies to see how that works out. I think the majority of employers, though, are slightly risk averse, at least, and don't want to be on the front edge of those, may not have the resources or otherwise, or risk reputation. But it's not
These are
automatic.
all considerations and assessments that need to be done thoughtfully and in a metered way.
Agree. All right. Well,
final thoughts.
Yeah. I'll give you the last word. I'll go first. I'll take a final thought on, we mentioned before, but I think particularly this 90 and 120 day window that we're in the middle of, making sure that you're working at the direction of counsel, how you invoke privilege. You can't just slap and say it's attorney privilege because we have the attorneys working. There has to be either a litigation threat or imminent risk of enforcement. I think we can probably clear that bar because of these new standards being put in place.
Right.
But as we move forward, we need to be mindful. Now, maybe you find existing EEOC charges that have been filed, and as a result of that, use that as a springboard to justify your attorney privilege. But I think being specifically mindful, recognizing this isn't routinized regulatory compliance that you're doing, and checking with counsel and making sure that he or she stands up the privilege in a way, because if the litigation gets started, whether it's
Yep.
through private claims or the government, you don't want to have this whole laundry list that can be used against you,
Agreed.
right?
My final thought is, if anybody knows me, develop a project plan. Um,
Preferably color coded.
It's gonna be color coded.
Yes.
But know your dates and your deadlines and what's coming up, and reallocate those resources. You're not going to be, many of you are on calendar year AAPs. Okay, you're not gonna be doing the heavy lift on the data cleaning, et cetera, on your calendar January plans. So let's use those resources to get your arms around your DE&I programs or the other items of what needs to be taken care of. And so that you are able to be fully prepared and moving into, because at the end of the 90 days, you want to know what components need to have been turned off by then, what you are comfortable voluntarily moving forward. And that involves a lot of work between now and then.
Correct. One other thing, if we just go to the next slide for a second, I just want to point out everything that we have talked about today, we have in the deck. It's been linked, so you can go to all the source materials, the 2 key executive orders we've talked about today, the White House fact sheet we've referenced, the acting secretary's order that stands down OFCCP, and the forbearance instruction that GSA issued. We're also going to be adding a resource page on our firm website. Stay tuned, more details coming on that, but that will be coming up in the very near future. So we will, anyone who is interested in that, get in touch with us. We're happy to give you a copy of the deck. Encourage you to use the deck if it's helpful in your internal briefings, et cetera. Please do, because I think a lot of folks have to explain to their organizations about what's going on, and if this is helpful and you meeting those objectives, please use that. All right.
We are right at time, but we welcome anybody out there who has questions that we didn't get a chance to get to. Please email those to David and I, and we're happy to get back to you with answers.
Yeah, we'll do our level best.
Yes.
All right, folks. Thank you. Have a safe day, and I think next week we'll be back again. Okay. All right.
Thank you.
Thanks.